A defendant who prayed his way through trial testified that he never intended harm. Then the jury convicted him on all counts anyway. The verdict turned on a single legal distinction. Sincere belief does not excuse criminal recklessness when a reasonable person would have recognized the danger.
Reflect the presence of the jury at this time. At this time, has the jury reached a verdict?
Yes, we have, Your Honor.
All right. And if you'll please hand the verdict forms to the bailiff. Arlene, if you'll bring those up to Jan. And the clerk will now read and record the verdict.
Your Honor, may I omit the captions?
You may.
Thank you. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Samuel Rapili Baitman, guilty of the charge of child abuse in relation to Shirley Baitman, as set forth in count 1 of the indictment.
He prayed his way through trial. The jury had other plans. The foreperson stood, verdict forms in hand, and read aloud what every person in that courtroom already feared or hoped to hear: guilty on all 3 counts of child abuse, each count found to be a dangerous offense involving a dangerous instrument, proven beyond a reasonable doubt. The defendant had just finished telling the jurors he would never intentionally harm anyone, that he cared about the witnesses beyond what he could express, that he asked God to bless every trip they took. The jury listened to every word of it. Then they convicted him anyway. This is what happens when a defendant's own testimony becomes the prosecution's most powerful evidence.
So I just want to remind us to please judge me on the facts and the evidence of this case. There's just not, you're not going to find evidence that I willingly, intentionally harmed these people, because I didn't harm them, and I didn't even have a desire to harm them. And in my mind, because I felt like I was a very good driver, I didn't feel like I was even endangered. And
by the end of this video, you will understand exactly what legal standard the jury applied to distinguish sincere religious belief from criminal recklessness, and why that distinction exists in the first place. The trial took place in Maricopa County, Arizona. The defendant, Samuel Rapili Baitman, faced 3 counts of child abuse under Arizona Revised Statute Section 133623, each classified as a dangerous offense involving the use of a dangerous instrument, specifically a cargo trailer that became a confined, unventilated, and unsecured compartment on a highway traveled at high speed. The victims were 3 women: Shirley Baitman, Gladys Johnson, and Dorothea Barlow. The prosecution argued that Baitman knowingly placed them in a situation that endangered their lives. Baitman represented himself with advisory counsel present. The judge presided over a jury trial that lasted several days. The charges carried the potential for prison time measured in years, not months. The dangerous offense designation meant mandatory consequences beyond the underlying sentence. An ordinary man with no criminal history was now facing the full weight of the state. Samuel Baitman was not a career criminal. He described himself as someone who liked exciting things: motorbikes, dirt roads, the kind of small adventures that fill weekends in rural towns.
And he mentioned that I was sitting in my real soft truck, but I would have easily got back there with him if I would have trusted somebody else to drive. I like that kind of stuff. That's the kind of person I am. I like exciting things.
He prayed before every outing. He believed he was a very good driver. He told the jury he would never put anyone in an extremely dangerous condition, not even an enemy.
Also, the other people may not have known my intention, but my intention was not to get on the freeway, because I understand the greatly increased danger with vehicles moving that fast and the big vehicles. I may not have told them that, but that was definitely my intention. And when I saw Ruth walking out of the...
On the day in question, he was transporting people in a cargo trailer. People who trusted him, people who had ridden with him before on slow dirt roads and around town. He lost his freedom the moment the verdict was read. He lost his bond. He lost the presumption of innocence that had protected him through every prior day of his life. The trial itself consumed weeks of his existence. The sentencing hearing was set for August 25th. Every day between verdict and sentencing would be spent in custody. The cost of this prosecution was not measured only in dollars. It was measured in the complete dissolution of an ordinary life. The prosecution built its case on a simple factual foundation. Baitman had placed 3 women inside a cargo trailer and driven onto a freeway. The trailer had limited ventilation. The door was not fully secured in the way passengers would expect. At some point during the drive, the victims realized their fingers could fit through a gap in the door. They made a phone call.
Because we saw that gentleman come up quite angry or quite bothered. And then it turned into exquisite pain and concern, and freaking out when I got the phone call as I was pulling off onto the freeway. When they said our fingers are sticking out the door, I'm just like, oh my goodness. So I got freaked out. I think I pulled off right at that middle on the side or at least as soon as I could, onto this median, or whatever you call it, emergency lane. And then that's what, right when I saw, right as he pulled up to me, that's when I pulled off. He went ahead with me, parked on the other side of the exit. And I just got back on the road and pulled into the exit. And so about half.
They were afraid. When law enforcement arrived, the trailer was opened from the outside and the women were found inside. The prosecution argued that any reasonable person would understand that transporting human beings in a cargo trailer at highway speeds, without proper seating, without safety restraints, without reliable ventilation, and without a means of exit from the inside, constituted a substantial and unjustifiable risk of harm. The statute required the state to prove that the defendant acted intentionally, knowingly, recklessly, or with criminal negligence. The prosecution believed the facts spoke for themselves. The trailer was the dangerous instrument, the freeway was the aggravating circumstance, the victim's fear was the human cost. The case appeared straightforward. Most people watching this hearing missed what just happened when Baitman testified that he did not realize the door was open until he exited the freeway, an admission that simultaneously confirmed the victims were trapped inside a compartment he could not see or monitor while driving, and that he made no effort to check on them before merging into high-speed traffic.
Also realized that I was totally unaware that the door was open until I entered the freeway. Until I got off the country club drive onto the off-ramp, or the on-ramp, I guess you call it. That's when I realized that they were in there, and I panicked. I didn't drive for miles and miles and miles. I didn't want to harm them. It was not my intention, and it never will be.
This detail passed without objection, but it will matter. The legal standard at the center of this case is found in Arizona's Child Abuse Statute, ARS 13-3623, which criminalizes conduct that places a child, or in this case, vulnerable adults under circumstances the law treats with equivalent seriousness, in a situation that endangers their physical health or safety. The statute does not require proof of actual injury. It does not require proof of intent to harm. It requires proof that the defendant's actions created a substantial and unjustifiable risk, and that the defendant was aware of and consciously disregarded that risk, or failed to perceive a risk that any reasonable person would have recognized. This is the distinction between intentional harm and criminal recklessness. The jury did not need to find that Baitman wanted to hurt anyone. They only needed to find that he knew, or should have known, that what he was doing was dangerous, and did it anyway. His prayerfulness, his good intentions, his belief in his own driving ability. None of that negates the legal question. The question the cross-examination needed to answer was not whether Baitman was a good man, but whether a good man can still commit a crime by treating sincere belief as a substitute for reasonable caution. Baitman cross-examined no one.
Okay, some of you may wonder why I didn't cross-examine these female witnesses. And it's because I care about them beyond what I can really express. And I decided years ago that if it ever came to trial, I would not ask them one question to make them feel uncomfortable, because I know it would. And I'm not sure what you're referring to about me saying extremely dangerous, but I don't think I ever said that. No, I would never put anyone in an extremely dangerous condition, not even quote-unquote an enemy.
He explained this choice directly to the jury. He said he cared about the female witnesses beyond what he could express and had decided years ago that if it ever came to trial, he would not ask them one question that might make them uncomfortable. The jury heard this. It sounded like compassion. It was actually a catastrophic strategic decision. A defense attorney would have asked whether the door was latched from the outside. A defense attorney would have established exactly how much ventilation existed. A defense attorney would have questioned whether the victims had ridden in the trailer before under similar conditions without complaint. Baitman asked nothing. The prosecution's witnesses testified without challenge. Their accounts of fear, of fingers sticking through the door gap, of the phone call made from inside the trailer, entered the record uncontested. Baitman then took the stand and testified that he did not know the door was open, that he panicked when he received the phone call, that his intention was never to get on the freeway, that he assumed the other passengers had exited when one woman got out, that the trailer was latched, and the victims were not in any real danger.
And as we heard before from Brenda's testimony, I think there was ventilation in there. It may not have been a whole lot, but there was ventilation. I tried it when I hopped in there that time right in there. And also the door was partially secure, from which the latch showed. I don't know if you know much about trailers, but when it's latched on the bottom, you just about can't get it open. Brenda thought that they might have shook open, but sorry, it's going to have to go over a big bump to get that thing to come open. So if their body cam footage was accurate, was assume it was, that door was latched and the girls were.
He told the jury the door could not have opened without a big bump. He told the jury he was a very prayerful person. He told the jury he did not use the restroom. Every statement he made was an assertion of fact offered without the foundation that cross-examination of the state's witnesses would have provided. He was asking the jury to believe him without having given them any reason to doubt the people who said they were afraid. The peak revelation arrived quietly. Baitman said he did not feel like what he did was dangerous. He said he felt like there was not even a chance of something happening that would cause harm. That single sentence, "I didn't feel like it was dangerous," was the prosecution's entire case, delivered by the defendant himself.
Perhaps what I did was reckless. I don't really everything you say about that. It might have been a little reckless, but I didn't feel like it was dangerous or else I would have done it. I felt like there was even a chance of something happening where they're going to be harmed.
Here is what that admission actually means in the real world. Criminal recklessness under Arizona law does not turn on whether the defendant subjectively believed his conduct was safe. It turns on whether a reasonable person would have recognized the risk. When a defendant testifies that he saw no risk in conduct that any reasonable juror would find obviously dangerous, he does not exonerate himself. He proves the state's point. The jury does not need to find malice. It only needs to find a profound and unjustified failure of judgment. What should have happened differently begins with the decision to proceed pro se. Baitman had advisory counsel. That attorney should have prepared him to understand that cross-examination is not cruelty. It is the mechanism by which alternative explanations enter the record. The officer who responded to the scene should have documented more precisely the condition of the trailer door, the latch mechanism, and whether it could be opened from the inside. The prosecution should have been required to prove, through expert testimony, exactly what temperature and oxygen levels existed inside that trailer at highway speed. Because without that evidence, the dangerousness of the condition was being inferred rather than measured. A properly prepared witness would have testified not about her subjective fear, but about the specific physical conditions that made escape impossible and breathing difficult. The defense should have challenged the application of the dangerous instrument designation by establishing that a trailer used routinely for short trips on dirt roads is not per se dangerous when used on pavement at low speeds. The failure to do so meant the designation attached automatically to every count. These failures are not abstractions. They are the reason an ordinary man who believed he was taking people on an adventure is now in custody, awaiting a prison sentence. The accountability mechanism for these failures is functionally non-existent. Advisory counsel cannot override a defendant's strategic choices. The officer's documentation will not be reviewed unless an appeal is filed, and the prosecutor's decision not to present expert testimony on environmental conditions inside the trailer will face no independent scrutiny, because charging discretion is among the most protected powers in the American legal system. The legal principle that connects the cross-examination strategy to the elements the prosecution was required to prove is found in the concept of mens rea, the guilty mind. ARS 13-3623 requires proof of at least criminal negligence, which Arizona defines in ARS 13-105 as the failure to perceive a substantial and unjustifiable risk that constitutes a gross deviation from the standard of care a reasonable person would observe. The defense's theory that Baitman did not perceive the risk was not legally sufficient because the statute also criminalizes the unreasonable failure to perceive risk. The cross-examination Baitman needed was one that would have established that a reasonable person in his position, familiar with this trailer, on this road, with these passengers, would not have perceived the risk either. That cross-examination never happened. Most people believe that if a defendant genuinely did not think his actions were dangerous, he cannot be guilty of a crime requiring criminal negligence. That is not what the law requires. The law requires the jury to compare the defendant's perception to what a reasonable person would have perceived. And when the gap between the two is vast enough, the defendant's sincere belief becomes legally irrelevant. This is the distinction the jury applied, and understanding it is what separates legal analysis from moral intuition. The prosecution's closing argument was simple. The trailer was a confined space. The freeway was a high-speed environment. The victims could not exit. The defendant chose the route, chose the speed, chose not to check on his passengers until the phone call forced his hand. That is criminal recklessness regardless of how sincerely he prayed or how much he cared about the witnesses. The defense closing argument, delivered by Baitman himself, was that his whole life testified to his character, that he never intended harm, that the victims had ridden with him before, that the door was latched, that the trip was never supposed to involve the freeway, and that his panic upon receiving the phone call proved he was not indifferent to their safety. Both arguments were coherent. Both had evidentiary support. The jury had to decide one question that neither attorney fully resolved: whether a lifetime of good intentions can legally excuse a single decision that a reasonable person would have recognized as unacceptably dangerous.
And that concludes my remarks. And I would just humbly ask you to consider the facts and consider my intent the best you can, and judge me not guilty. That's just my humble prayer. Thank you.
Thank you, Mr. Baitman.
The judge polled the jury. Each verdict was confirmed: guilty on count 1, guilty on count 2, Guilty on count 3.
We further find count 1 to be a dangerous offense involving the use of a dangerous instrument proven beyond a reasonable doubt. Signed by juror number 3, foreperson. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Samuel Rapili Baitman, guilty of the charge of child abuse in relation to Gladys Johnson, as set forth in count 2 of the indictment. We further find count 2 to be a dangerous offense involving the use of a dangerous instrument proven beyond a reasonable doubt, signed by juror number 3, the foreperson. We, the jury, duly impaneled and sworn in the above entitled action, and upon our oaths, do find the defendant, Samuel Rapili Baitman, guilty of the charge of child abuse in relation to Dorothea Barlow, as set forth in count 3 of the indictment. We further find count 3 to be a dangerous offense involving the use of a dangerous instrument proven beyond a reasonable doubt.
Dangerous offense designation applied to every count.
All right, thank you, Joe.
Members of the jury, are these your true and correct verdicts?
Yes.
And at this time, does either party wish to poll the jurors?
No, Your Honor.
Baitman's bond was revoked.
August 25th at 2:30.
That does work for the state, Your Honor? Yes, I'm okay with waiving time.
All right, what would the time be again?
At 2:30.
At 2:30 also. Can I ask, Ms. Breskas, can you ask that date be suitable for the victims? All right, I appreciate that. With that input from the victims and both of the parties, and Mr. Bateman's willingness to waive time beyond the usual 30 days, the court will set the matter for sentencing on August 25th at 2:30 p.m. A pre-sentencing report is ordered.
The legal principle the verdict upholds is that criminal recklessness is measured by what a reasonable person would have perceived, not by what the defendant claims to have believed. This is the same reasonable person standard that runs through American tort law, through Fourth Amendment reasonableness analysis, through the Model Penal Code's definition of criminal negligence, the idea that the law does not bend to accommodate every individual's subjective risk assessment, because if it did, the most dangerous people would simply be those most sincerely convinced of their own harmlessness. The jury's verdict affirms that principle. A criminal justice system that only punished intentional harm would leave the most vulnerable people unprotected from the recklessly confident. The drivers who believe their reflexes make speed limits unnecessary. The caregivers who believe their instincts make safety protocols redundant. The defendants who believe their prayers make precautions optional. The jury in Maricopa County drew a line that day between sincere belief and legal responsibility, and that line is the only thing standing between every ordinary person and the unreachable interior of someone else's good intentions. In that, Samuel Baitman convicted because he genuinely endangered those women, or was he convicted because he represented himself and failed to challenge the prosecution's evidence in a way a trained attorney would have? And if the second explanation is true, does the right to self-representation actually serve justice, or does it serve the illusion of choice while guaranteeing a predetermined outcome?